We have breaking news surrounding the election interference charges against Donald Trump. The former president notifying Fulton County's court he may seek to have the case removed to federal court. Let me bring in MSNBC legal analyst Lisa Rubin. I was going to say you had to read through all this, but it's basically 4 lines long. What actually does this mean?
So this is not a notice of removal. Donald Trump is letting Judge Scott McAfee in Fulton County Superior Court know that he may, at a later point in time, file a notice of removal to federal court. The reason he's doing this now is because, as Judge McAfee noted the other day in his hearing, if cases get removed to federal court, then the whole question of how to schedule these other 17 defendants for trial is either moot or presents additional legal complexity for him. He mentioned the other day, let's say Mark Meadows loses on his removal motion in federal court, but the 11th Circuit then reverses that. Says, what happens if I've already tried all of you here in my court, and at a later point in time, a federal appeals court finds that the case should have been tried in federal court? So Trump is basically saying to this judge in the state, here's one more factor for you to consider among the other people who have already moved to remove. I might add my name to that pile, too.
All right, I want to go back to that, but let me back up for a second. If that is the decision that Donald Trump makes, would he even file this in state court?
No, he would not. He would file a notice. So the first step would be to file a notice of removal in federal district court. That's the Northern District of Georgia. And according to statute, that notice of removal has to state his grounds for removal, too. So you and I are looking at this notice that he just filed in state court. It's a paragraph long. It doesn't really say anything. If he actually seeks to remove his case to federal court, he's going to have to provide some grounds and justification for doing so, which includes that he was acting as a federal officer at the time and that he has a colorable federal defense to being prosecuted by the Fulton County District Attorney. Mark Meadows, in his motion, says his colorable federal defense is essentially that he's immune from prosecution by the state because, as the White House Chief of Staff, he was acting pursuant to federal law, and that means under the Federal Supremacy Clause of the Constitution, no state prosecutor can touch him.
Let me go back to square one, okay?
Yes.
What would be the advantage for any of these folks, any of the 17 whose trial dates have not been set, of moving from Georgia beyond what a lot of folks have suggested, which is they don't want this to be televised?
There are 2 other possible advantages. One is that the jury pool changes. If you are tried in Fulton County Superior Court, the jury is drawn from Fulton County and Fulton County alone. That's a county that voted over 70% for Joe Biden in the last presidential race. If you are tried in federal court in Atlanta, on the other hand, that jury pool is drawn from, I believe, somewhere between 8 to 10 different counties in the surrounding area. The thought is that the jury pool gets progressively more diverse, more conservative, more favorable to people like Mark Meadows and Donald Trump. The other advantage is that federal courts have more experience with federal law. If you're a person who's going to say the federal Constitution makes me immune from prosecution, you might find a more receptive audience among a federal judge than you might among someone like Scott McAfee, who is a state court judge and a former assistant district attorney.
But bottom line, one more consideration for Judge McAfee as he has to make those decisions.
That's right. And he's already indicated he's not likely to try these 17 other defendants on an expedited time frame. I think this makes it increasingly unlikely that he will do so.